everyone, I'm Nazarat Fatima. Welcome to LiveLaw. The hearing in the Article 370 matter continued with the arguments of Senior Advocate Mr. Zafar Shah, appearing for the J&K High Court Bar Association, preceded by Senior Advocate Kapil Sibal and Senior Advocate Gopal Subramaniam. The Constitution Bench, comprising Chief Justice of India D.Y. Chandrachud, Justices Sanjay Kishan Kaul, Sanjeev Khanna, B.R. Gawai and Surya Kant, was hearing the matter. Let's take a look into the arguments made by Mr. Zafar Shah. Senior Advocate Mr. Zafar Shah emphasized over the autonomous nature of the erstwhile state of Jammu and Kashmir. He took the bench through the history of Jammu and Kashmir's accession with India and the subsequent formation of the Constitution of J&K. He first highlighted that the Maharaja of J&K did not hand over his entire sovereignty to the dominion of India and instead kept with himself certain powers, including the power to make laws, except those relating to foreign affairs, communication and defense. The Learned Counsel argued that the residual power of the Maharaja was included in Article 370, which indicated that it would be entirely for the people of J&K to integrate with India. He argued that J&K had not signed a merger agreement with the Dominion of India like the other states. Instead, it had signed the instrument of accession to shake hands with India but not embrace it entirely. Later, he elaborated upon Article 370 and stated that since J&K had already donated some of its powers to India in the instrument of accession, namely the power of defense, communication and foreign affairs, the state wanted there to be more donation. Therefore, Article 370 was framed in a manner where its consultation or concurrence was necessary to make laws. He asserted that there were limitations provided in Article 370 itself with regard to the power of the Indian Parliament to make laws for Jammu and Kashmir. One of those limitations was that if a law was to be made on a subject provided under List 1 or List 3, which was not a subject covered by the instrument of accession, the concurrence with the state government was required. This, according to the Learned Counsel, meant concurrence of the people of the state via the Council of Ministers. He reiterated that this special treatment was given to Jammu and Kashmir because there was no merger agreement it had signed. Therefore, the autonomy granted to Jammu and Kashmir had to be maintained. He argued that there existed a limitation on Parliament to make laws in Jammu and Kashmir because despite having acceded with India, the mechanism for J&K was different as it had subsumed the residuary authority that Maharaja had. He added, and I quote, "We believe that we have constitutional autonomy under the Constitution of India itself. That was taken away. We are contending that you cannot take away the autonomy of the state. This autonomy comes from the instrument of accession and Article 370. In continuation, Mr. Shah argued that Jammu and Kashmir had retained some constitutional autonomy as it had signed an instrument of accession and not a merger agreement. He argued that at the time of accession to India, the erstwhile Maharaja of J&K had retained certain powers, such as the power to make laws other than laws on defense, communication and foreign affairs, and this was embedded in Article 370. He also said that after the adoption of J&K Constitution, the state legislature was given the powers over the subjects in the residuary entry instead of the parliament. He highlighted that the state legislature of J&K had more powers as compared to the other states in India, owing to the fact that the other states had merged with the Dominion of India and had no personality of their own. However, with regards to J&K, it was the state's concurrence which was necessary to pass certain laws. He asked a question, and I quote, "Does it come to your lordship's mind that when Article 370 came in, did they proceed on an assumption that this Constituent Assembly of J&K will recommend to the Union of India to do away with 370 so it completely integrates?" In response to this, Justice Sanjeev Khanna immediately expressed his reservations on the use of words "completely integrates" by Mr. Shah and emphasized that the integration of J&K with India had already taken place as per Article 1 of the Constitution of India. Mr. Shah argued that the 2019 developments cannot negate the historical circumstances and that the context surrounding Article 370's enactment was crucial to understanding the issue. The Chief Justice of India D.Y. Chandrachud intervened at this juncture, stating that the surrender of J&K's sovereignty to India was unconditional and absolute. He highlighted that in 1972, Article 248, which provides the Parliament with residuary powers, was amended and the Parliament was given exclusive powers to make any law with respect to prevention of activities directed towards disclaiming, questioning or disrupting the sovereignty and territorial integrity of India. The CJI said, and I quote, "The order of 1972 makes it beyond doubt that sovereignty is vested exclusively in India. Therefore, no vestige of sovereignty was retained post the instrument of accession. Is it correct that Article 248, as it is applicable to J&K immediately before 5th of August 2019, contains an absolutely clear and unequivocal acceptance of sovereignty of India?" In response to this, the Learned Counsel stated that the legal question which arose was that when a state acceded, it was asked if it transferred its sovereignty to the Union of India. J&K had stated no to the same, and such sovereignty could only be transferred by terms of a merger agreement. Upon hearing this, Justice Khanna asked, "What is superior? Is the Constitution of India superior?" Mr. Shah responded in an affirmative manner, and the Chief Justice elaborated that various provisions in the Constitution required concurrence with states, but it did not necessarily undermine the sovereignty of the Union of India. He stated that limits on lawmaking powers of Parliament were built into the Constitution's design due to India following a system where power was not solely centralized. He underlined that the same did not reduce India's sovereignty, but simply put a boundary on what the Parliament could do. The CJI said that the post-Article 370 Constitution should not be seen as a document that preserves any remnants of sovereignty within the erstwhile state of J&K. Responding to this, Mr. Zafar Shah countered and asked, "What about the constitutional provisions that necessitate concurrence and wherein the President applies modifications post-concurrence? Is such a provision applicable to other states as well?" He highlighted that he was only claiming the constitutional autonomy which was taken away from J&K. He said, and I quote, "How do we get that back? By demonstrating to this court what we had. I still have the constitutional autonomy, maybe little. Maybe it's a skeleton, as Justice Kaul said, but somebody felt that the skeleton was disturbing him. Therefore, he got it off." These were some of the major arguments made by Senior Advocate Mr. Zafar Shah. We'll be back with part 2 of the arguments very soon. That'll be all for now. We hope you like our content. If you do, please like and share our videos. Also subscribe to our channel on YouTube. And don't forget to press the bell icon for notifications. Thank you for watching.